Okay, good morning, good afternoon, or good evening. No? It depends on what time are you watching this video. So this would be the start of our discussion regarding contracts. So in this video, you will see or we will discuss the general provisions of contracts. So, as provided under Article 1305, a contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render service. It may also be defined as a juridical convention manifested in legal form by virtue of which one or more persons bind themselves in favor of another or others or reciprocally to the fulfillment of a prestation to give, to do, or not to do. As being distinguished from conventions, a convention is broad enough to include any kind of agreement which may create, modify, or extinguish patrimonial and even family relations. A contract, on the other hand, is limited to agreements which produce patrimonial liabilities. Okay? So here, the outline of our discussion or of this video are as follows. We have the elements of a contract, classification of contract, stages of contract, and the basic principles. To start with the elements of a contract. The elements of a contract, the first one are essential elements, okay, without which there will be no contract. The essential elements are those necessary for the very existence of the contract itself, no? The absence of any one of these essential elements will prevent the creation or existence of a contract. In other words, the contract is inexistent in the absence of any of these essential elements. Now, as provided under Article 1318 of the Civil Code, there is no contract unless the following requisites concur. One is consent, second is object, and third is cause. These three requisites are therefore the essential elements of a consensual contract. In real contracts, however, in addition to the above, the delivery of the object of the contract is required as a further requisite. Hence, in real contracts, the essential elements are consent, object, cause, and delivery of the object of the contract. The discussion of the essential requisites of the contract will be discussed in the next video. Okay? The second element of a contract are the natural elements, which is found in certain contracts unless set aside or suppressed by the other parties. These elements are not essential for the existence of a contract, but they are presumed to exist in certain contracts. Okay? And what can be an example of this one? A good example is warranty in case of eviction in a contract of sale. Warranty against eviction is a natural element of a contract of sale, although the contracting parties may increase, diminish, or even suppress it. And the third one is or are the accidental elements. These refer to particular stipulations of the parties. Take note that these elements exist only when the parties expressly provide for them. These are the clauses, terms, and conditions that the parties may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. So these are the three elements of the contract. Essential elements, natural elements, and the accidental elements. Now let's proceed to the different classification of a contract. Actually, there are so many classifications of a contract, but I've chosen only 5, no, according to perfection or formation, classification according to cause, classification of contracts according to its importance, according to its name or designation, and according to the risk or fulfillment. So let's have or discuss this one by one. Okay? So for perfection or according to perfection of contracts, so let's have this one. Perfection or formation, it is either consensual, real, or formal. Consensual means that which is perfected by mere consent, an example of which is a contract of sale. On the other hand, real, when we say it is real, that which is perfected not by mere consent, but by the delivery of the object of the contract. And under the Civil Code, the following contracts are classified as real contracts. We have deposit, pledge, mutuum, and comodatum. And finally, according one of the classification of contracts according to perfection of formation are formal, which must be in the form provided by law for their perfection. Next classification is according to cause. Okay. It is either onerous, gratuitous, and remuneratory. Okay, when we say onerous, that where the cause is understood to be for each contracting party, the prestation or promise of a thing or service by the other. So there is an exchange of valuable considerations. An example of which is a contract of sale. You pay for the item that you will purchase. When we say gratuitous, that where the cause is the mere liberality of the benefactor and that where one party receives no equivalent consideration. An example of which is the contract of comodatum, which is essentially gratuitous. And lastly is remuneratory, that where the cause is the service or benefit remunerated. A donation given in consideration of a past service which does not constitute a demandable debt, for example, is classified as a remuneratory donation. Next classification is according to importance or dependence upon another. So we have here principal. Okay, it could either be principal, accessory, or preparatory. When we say principal, it's one that can stand by itself, no? That which can exist independently of other contracts. An example of which is a contract of loan. Accessory, that which cannot exist without a valid principal contract. So its existence depends upon another contract. Under our laws, the term accessory contract is synonymous with contracts of guarantee, such as guarantee proper, surety, pledge, and mortgage. These contracts exist merely to secure the fulfillment of a principal obligation. And lastly is the preparatory. That which is not an end by itself but only a means for the execution of another contract. So it serves as a means by which the other contracts may be entered into. Okay? A contract of agency, for example, is a preparatory contract, as agency does not stop with the agency because the purpose is to enter into other contracts. Next classification, according to their name or designation, we have nominate and innominate. Nominate, when we say nominate, that which is distinguished by a particular or special name in the Civil Code. Examples of nominate contracts are sale, lease, and deposit. So these have a name, which have a name under the law. And innominate, when we say innominate, that which is recognized in the Civil Code, but not specially named or classified in the said code. What are examples of this? We have 4 kinds of innominate contracts. We have do ut des, I give that you may give. I give that you give. Second, do ut facias, I give that you do. Third, facio ut des, I do that you give. And fourth one is facio ut facias, I do that you do. So these are innominate contracts. So these contracts shall be regulated by the stipulation of the parties, by the provisions of obligations and contracts, by the rules governing the most analogous nominate contracts, and by the customs of the place. So that is according to their name or designation. Next is as to risk or according to risk or fulfillment. We have commutative, okay, where parties give equivalent values. Here, or there is a mutual exchange of relative values. A good example is the contract of sale where the seller gives the thing sold in exchange for the purchase price and the buyer pays the price in exchange of the thing sold. Okay, that is commutative. That in which each of the contracting parties gives and receives an equivalent, or there is a mutual exchange of relative values. The next item, according to risks involved, is are aleatory contracts that in which each of the parties or both reciprocally bind themselves to give or to do something in consideration of what the other shall give or do upon the happening of an event which is uncertain or which is to occur at an indeterminate time. Here, the element of risk dependent on chance is predominant. And a good example of aleatory contract whose fulfillment depends upon chance is a contract of insurance. Okay? Now let's proceed with the stages of contract. We have 3 stages: preparation or conception. The second stage will be the perfection or birth of the contract. And final stage should be the consummation or death or termination of contract. Okay. So let's start with the preparation or conception of contract. Okay. For preparation or conception, so a contract undergoes 3 distinct stages now. So in preparation, negotiation, it begins from the time the parties manifest their interest in the contract, okay, and ends at the moment of agreement of the parties. Okay, that's the first stage, the preparation or conception or negotiation. Okay. The second one is the perfection of contract. When we say perfection of contract, this is when the parties agreed upon essential elements of a contract. The stage of the birth of a contract is referred to as its perfection, right? But prior to perfection, no contract is created. Thus, until a contract is perfected, it cannot, as an independent source of obligation, serve as a binding juridical relation. And what could be the manner of perfecting contracts? We have 2, no? If, for example, when we say consensual contract, a contract which is consensual as to perfection is so established upon a mere meeting of minds. Okay, thus the rule that contracts are perfected by mere consent, and from that moment, the parties are bound not only to the fulfillment of what has been expressly stipulated, but also to all the consequences which, according to their nature, may be in keeping with good faith, usage, and law. A contract of sale class is consensual contract, which means that the sale is perfected by mere consent. On the other hand, when we say real contract, the manner of perfecting real contract, no, is that it is not perfected by mere consent, but by the delivery of the object of the contract. Under the Civil Code, there are 4 contracts which require delivery for their perfection. And kindly take note of this. We have comodatum and mutuum, an accepted promise to deliver something by way of comodatum or simple loan is binding upon the parties, but the comodatum or simple loan itself shall not be perfected until the delivery of the object of the contract. Second contract is a deposit, wherein an agreement to constitute a deposit is binding, but the deposit itself is not perfected until the delivery of the thing. Okay, and finally, we have pledge. It is necessary in order to constitute the contract of pledge that the thing pledged be placed in the possession of the creditor or of a third person by common agreement. And finally is the consummation or death or termination when parties fulfill or perform the agreement. This is the last stage, culminating in the extinguishment thereof. Okay. To proceed with the basic principles of contract, we have the liberty of contract, mutuality of contract, and relativity of contract. So these basic principles, I hope you will remember always, no? Okay, these are the parang groundworks talaga in studying contracts. Liberty of contract. Start with liberty of contract. So here, in liberty of contract, ano bang sinasabi nito? Okay. You can choose whoever you would want to enter into a contract, no? You are of liberty. Liberty nga, freedom of contract. The principle states is that the contracting parties are accorded the liberality. I'm sorry. Meron ba? Oh, hindi pa pala. No, not yet. Liberty of contract. Okay, the contracting parties are accorded the liberality and freedom to establish such stipulations, clauses, terms, and conditions as they may or as you may deem convenient, provided the same are not contrary to law, morals, good customs, public order, or public policy. In the law on contracts, such fundamental principle is known as the autonomy of contracts. Okay? May freedom. Okay? The right to enter into lawful contracts constitutes one of the liberties of the people of the state. If that right be struck down or arbitrarily interfered with, there is a substantial impairment of the liberty of the people under the Constitution. So that is, such freedom is protected by the following provisions in the Constitution. One, wherein, as provided in the Bill of Rights, no person shall be deprived of life, liberty, or property without due process of law. And the one, that refers to the due process clause, no? And then the other one is the non-impairment clause, where it stipulates that no law shall be passed impairing the obligations of contracts. So that's the liberty of contract. And then for mutuality of contract, ano bang sinasabi? What does this principle states as provided under Article 1308 of the Civil Code? Expresses what is known in law as a principle of mutuality of contracts, which provides that the contract must bind both the contracting parties, its validity or compliance cannot be left to the will of one of them. This binding effect of a contract on both parties is based on the principle that the obligations arising from contracts have the force of law between the contracting parties, and there must be mutuality between them, based essentially on their equality, under which it is repugnant to have one party bound by the contract while leaving the other free therefrom. The ultimate purpose is to render void a contract containing a condition which makes its fulfillment dependent solely upon the uncontrolled will of one of the contracting parties. Okay, na-click ulit. And finally, the third basic principle is the relativity of contract. Okay, relativity of contract. The principle of relativity of contracts provide that contracts can only bind the parties who entered into it, and it cannot favor or prejudice a third person even if he is aware of such contract and has acted with knowledge thereof. A contract can only obligate the parties who had entered into it or their successors who assume their personalities or juridical positions, and that concomitantly a contract can neither favor nor prejudice third persons. Take note that the general rule is that heirs are bound by contracts entered into by their predecessors in interest, except when the rights and obligations arising therefrom are not transmissible by nature, stipulation, or provision of law. As a rule, therefore, he who contracts does so for himself and his heirs. Thus, if the predecessor was duty-bound to reconvey land to another, and at his death the reconveyance had not been made, the heirs can be compelled to execute the proper deed for reconveyance. Okay, so these are the basic principles of contract. Okay, but there are exceptions. No, before I forget, there are exceptions to the principle of relativity. One, exceptionally, a contract may confer benefits to a third person or what are otherwise known as stipulation 403. Second, in contracts creating real right, third persons who come into possession of the object of the contract may be bound thereby under the provisions of mortgage laws and land registration laws. Third exception, creditors are protected in cases of contracts intended to defraud them. Okay? And then we also have this exception wherein any third person who induces another to violate his contract can be made liable for damages to the other contracting parties is provided under Article 1314. Tama ba? Article 1314. Yeah, I think that's good. So that would be all. No, I think this would be the end of the session, but wait, there's more. We will have, or I'll be posting a quiz in the Google Classroom. So if you have questions, kindly write it down. So by the time that we will have our synchronous class, you already have the questions prepared and we will discuss it. Okay? Thank you for watching this video and keep safe always.